Well, welcome everyone to another episode of the MedBriefing. I'm, for anyone who doesn't know me, Adam Stead. I'm CEO of MedBrief. And I've got with me today Brendan Hughes, who's the CEO of our parent company, Lex Vision, and the chairman of the MedBrief board. Welcome to MedBrief.
Thank you, Adam. I'm excited to finally get an invite to appear with you on the MedBriefing. It's funny to be doing this. I mean, we talk pretty much every day, but never recorded our conversations for anyone else to listen to. So this is probably going to be a lot of fun, and I hope it's informative and interesting for the listeners.
Well, we've been working together for a long time now. Probably our first exposure to the legal industry and how legal documents and corporate legal departments manage those was in the mid to late 90s. Is that right?
Yeah, I remember it extremely well. I think it was a very exciting stage of our lives, very formative part of our working lives. We graduated law school in 1997. And 1998 and 1999, we were working in London together in the legal document management industry as paralegals. So processing evidence required in court cases for large London Magic Circle firms. And I think that gave us our first exposure to the legal industry was from the perspective of information management and document management. You'll remember in those days, scanning was pretty much the latest technology in play, as well as optical character recognition, OCR, of scanned documents to extract text, burning images to compact discs, and couriering them between law firms was pretty much how information was securely shared in those days. So it was certainly an interesting time to witness the sort of introduction of the internet technologies that came about pretty quickly after that in the early 2000s. So yeah, a very good time, and we managed to fit in a lot of good traveling and backpacking in between all of our stints in various photocopier departments for law firms. So, yeah.
Yeah, and then we came back and we both entered the practice of law, me for a much shorter period than you. But we probably had a combination of the entrepreneurial bug, and also we were experiencing some of the frustrations that we'd first been exposed to in London with technology changing, document formats changing, but no real tools to try and solve the problems that were now being presented.
That's right. And I think you mentioned the word tools. And one of the reasons I think a lot of people study law and go into legal practice is they see law as a tool for administering justice, right? But if you get the sense that maybe that tool needs some other tools to help make it more efficient, that's also a pretty noble place to spend your time. And certainly some of my experience working in legal practice was that clients frequently get frustrated with the amount of time that it takes to resolve a dispute, and frequently frustrated with the cost that it takes to resolve a dispute. And that's a big problem for societies that want to be based on the rule of law. And coming into the profession as we did in the early 2000s, where the internet was a new technology and some of the more senior lawyers in practice weren't as familiar or coming to grips with it as maybe some of the new entrants, we were given a lot of opportunity to skill up in those technologies. And, the penny dropped pretty quickly that you could make a major impact, or at least hopefully a meaningful impact on the legal profession if you invested time in developing the technology tools that would make the profession more efficient. And the entrepreneurial bug, I think, had bitten us both, and that was really the formative backstory to why we went into legal tech as a career at that point.
So, Brendan, you've thought about that experience from an in-house practice perspective, but what about in an enterprise perspective and in-house legal counsel?
Yeah, I think the frustration is there for general counsel as well, in the large enterprise space as well. I think general counsel are under increasing pressure to try their best to keep legal spend down to a minimum, but the stats are probably trending in the opposite direction currently. If you look at the 2025 Norton Rose Litigation Risk Report, they were reporting high frequency of litigation, in particular for North American enterprises. The average large North American enterprise is engaged in approximately 62 concurrent simultaneous lawsuits. And in the 2026 Shoesmith's annual litigation report, they are reporting from a survey of 360 in-house legal counsel from a wide variety of enterprise sectors, that more than 70% of those in-house counsel are projecting an increase in their legal spend, their litigation spend in the next year, and that more than 30% of high-value cases are resulting in legal bills in excess of £1 million. And again, I think more than 70% of the survey respondents are indicating that they are intending to increase headcount in their in-house legal departments. So as much as there are pressures to make things more efficient, currently it seems that society is still quite litigious, and the litigation costs are currently increasing, and the need for litigation resources is increasing also. So there is a frustration that I think we need to tap into solving, about how really we can develop technology solutions that genuinely drive down legal costs and mitigate risks. It is a massive problem for the enterprise.
Yeah, and it's not just an enterprise problem. It's a macroeconomic and governmental problem as well. And I want to think about this from the perspective of healthcare, and in particular in the UK with respect to the NHS. And the NHS is quite correctly regarded by pretty much everyone as a national treasure and a core kind of component of their national identity. But worryingly, on the other side, it's true to say that there are significant contingent liabilities that are now representing nearly £60 billion worth of spending that the government ought really not to have to be making. That, I think, is the second biggest liability on their balance sheet, on the government's balance sheet, after nuclear decommissioning. And so the problem really to be addressed is, how do we find a way of reducing that without prejudicing access to justice?
Yeah, that is a great question, because I think some of the simple responses to that problem, to say let's introduce a cap on claims liability, ultimately prejudices the public as well, because why should a person not be entitled to fair compensation? So really the ultimate goal is to reduce the events giving rise to harm, and perhaps the best way to do that is to extract the learnings from the past events that have given rise to harm. So it points to the pivotal role that I think information, insight, and aggregated learning can bring from past cases, with a view to bringing down those costs. I mean, could you imagine if the UK government could reduce those contingent liabilities from £60 billion to £10 billion? That's £50 billion of taxpayer-funded money that can be reinvested into other areas of the economy. So, yeah, I think it's about grappling with the problem of what's causing these events, and doing the best that we can to try to mitigate those events in future. I think for a business like MedBrief, it's an exciting opportunity to play a role in designing the solutions for problems like that.
So, Brendan, you mentioned a cap, and I think that's the broader insight is really that there is no one single silver bullet to address this problem. The government is, and courts are, reaching for a variety of different solutions. For example, fixed recoverable costs. Those might not necessarily be a bad thing. The legal aid environment is a lot more restrictive now. I think that's somewhat problematic, because people with potentially meritorious claims but that lack quantum for one reason or another are not being pursued by solicitors.
I agree, Adam. And I think it's very easy for us to get a little despondent about the picture. We can paint a bleak picture, but at the same time, I think it's a good idea for us to try to inject a little radical optimism into the approaches that we take. And that's not just the title of a Dua Lipa's latest album, but a philosophy I think we could embrace. And radical optimism is distinguished from naive optimism, which is that everything's going to work out fine, but we're not engaging with reality. I think the important headspace for us who work in the legal industry, the litigation risk industry, to be in is to engage with the reality of the problem, engage with the size of the problem, engage with the nature of the challenges, the complexities of the challenges, but keep a positive perspective that we can solve these problems if we think creatively, we apply innovation and technology effectively. That's the philosophy I think we should be in. So, I'm curious to ask you, you focus specifically on the medico-legal and personal injury litigation market. Are you seeing signs of, positive and exciting developments to suggest that, we're making significant progress in these areas?
I am. I mean, the founder of the NHS, Nye Bevan, said that the NHS will last as long as there are dedicated people left to fight for it. And I see those people all around me. The solicitors that I interact with, the people at MedBrief, we're all extremely dedicated to improving healthcare in the UK. And that really is on the claimant and defendant side. So, no, I'm extremely optimistic about the future and about what MedBrief in particular can bring to that future.
It's certainly a pivotal time. And I think attitudes, we should talk about AI. We're certainly going to get into a conversation about AI, but attitudes around AI are formulating and changing every month at the moment, I think. Initially, there was some skepticism. Then there was incredible excitement and hype. Now, perhaps a little bit of fear and disillusionment amongst professionals. Are they going to lose their jobs, or are they going to become more empowered to do their jobs? But I'm, I guess, one of the people who is incredibly optimistic about what we can do with AI if we develop it responsibly, intelligently. We figure out the power constraint problem. Those are really important areas for us to keep innovating for the long-term impact that I think it's going to bring. But AI as well, it's also been around since we were kids or before we were kids, because I always think about the old solar-powered calculators. You might have had one. I definitely had one when I was at school. And think about that was a energy sustainable way of calculating maths problems, without having to do it yourself, the manual way. So there's just been various iterations of AI over the years in the litigation, disclosure, discovery industry. We've had predictive coding for a number of years, the ability to use regression logic systems to determine whether documents are relevant or privileged. That's been around for a long time. We were just calling things like that machine learning for a decade or more. And now, obviously, the phrase artificial intelligence has probably really come about because of the language-based approach to AI in recent times, the language models, the chatbots. And I think it was Alan Turing who probably defined what's known as the Turing test. The test for artificial intelligence is when you're interacting with the system and you can't distinguish it from a human being. So I think people have used the term artificial intelligence from the classical Turing definition of it to say, well, it's arrived now because I can't tell that I'm chatting to a computer. But actually, we've been using AI to make people more efficient in the workplace for many years, and this is just the latest iteration. And I think it's a positive development that we need to embrace as an industry.
Yeah, I'd agree. I think the example that you used at the beginning was the calculator. And I think much of the cynicism around AI actually stems from the early experience that we had with a calculator, which is very deterministic. Like, you plug in the numbers and you get out an answer. And the last maybe 10, 15 years of AI, and in particular the last 3 years with the LLMs, it's all probabilistic. And so you're getting out something of a magical answer, but it's certainly not a necessarily expected answer.
And you mentioned the probabilistic approach, right? And I think when you're dealing with a legal problem in particular, we need to be very careful about the types of decisions that we make based on probabilities and those types of decisions that we make based on logic and conditional logic in particular. We've always had probability assessments within the legal system. When you're called upon to determine whether something is true or false beyond reasonable doubt, you're talking about probabilities. Or when you're asked to prove something on a balance of probabilities, you're obviously talking about probabilities. But when you are coming up with your legal reasoning for making a decision or holding an opinion, you need to be able to substantiate your decisions based on logic. And I think that's why there is an increasing amount of skepticism about the language model-based approach to AI for certain types of legal processes, because a legal system is not a language system. If I've gained any insight from studying law, practicing law, working in legal tech, and I think quite deeply on some of the problems about how to design technology systems for legal processes, probably one of the main insights that I've had is that a legal system is an entity relational system. It is a codified system that defines how different entities in different types of relationships occupy different relationship roles, and each of those relationship roles carry different relationship rights or relationship obligations. And all laws can be expressed as a set of conditional statements describing how entities need to interact with each other when they occupy different roles and in different relationships. So, that's why I think the design that we're certainly pursuing at LexVision from an innovation side around data models for the legal system is based on entity relational models and not language statistical models. Although the language models become extremely important when processing language content or when wanting to write up opinions or judgments, but ultimately everything needs to track back to a set of logical conditions to make sure that you're eliminating those hallucinations that we see with the language models. I mean, we've seen plenty of examples now of completely made up judgment citations in language model produced opinions, and I think the risk of a statistical based approach to reasoning is very clear. Law can't be determined based on statistics and past cases and past texts. It has to be based on reasons, and every case has to be assessed on its own merits. So I'm excited to see how reasoning systems develop in the legal system, and I think that's the next wave of development. It's going to be an exciting time for us to play a part in that, that's for sure. I think language models are going to play a very big role, but they're not going to be the whole solution. The solution has other elements to it. One of the areas that I think is going to become increasingly important is the use of sort of graph database systems, because we focus heavily on entity relations and events that happen between entities. Graph database systems are obviously designed from the ground up to handle large-scale, complex relationship-based queries. So I think we're going to see an evolving future of graph databases in the legal system AI architectures of the future. And the other thing is all of these models and all of these solutions are quite big projects to run and to deploy and to host. So the question of transferring legally sensitive, potentially privileged, in some cases with MedBrief, like medically sensitive information, to a sort of central location where you have sufficient disk space and compute resources to process all this information is also something that's going to have to be an area of innovation, because we need to make sure that we're solving the privacy problem. We need to make sure that we're solving the privilege problem. I think you will have seen comments by some of the leaders of some of the big generative AI companies speaking about this as a problem. People tend to ask very sensitive, confidential questions of AI without realizing that they're handing custody of that data to a third party, particularly if you're not using enterprise editions of those types of software. So I think it's really important to make sure that when you design these solutions, you're not just designing for a technical solution, you're also designing for a privacy solution, a legally privileged solution as well. And that's something at the moment that I think we're trying to play hopefully a leading role in the design of privacy protocols to protect information. I mean, for anyone who's subscribing to MedBrief systems, they can tell exactly where in the world their data is, right down to the specific data center, and the information is not transferred from that data center outside of the data center to anyone else. Measures like that are also going to be incredibly important. I think sometimes when we get focused on the tech and the research, we forget that actually there's certain rules around who can hold data, who can process data, and those definitely need to be taken into account as well. Adam, let me ask you a question. What is the thing that's exciting you most about 2026 in your role as CEO of MedBrief?
I think 3 things, probably. The first thing is something I've been very excited about for the last 12 to 18 months, but I think what they're going to achieve in the next 12 months is going to be the realization of some of the hard work that they've been putting in. And that thing is the team. So we've got a team, multidisciplinary team working on AI. We're about 100 people, just over 100 people now. And a good portion of those have at some time or another worked on AI projects. So we've got AI engineers, we've got data scientists, we've got ML ops people, we've got solicitors, we've got clinicians, we've got software developers, all trying to build these incredibly difficult pieces of software to solve these hard problems. And I'm really proud of the work that they're doing. And it brings me to the second thing that I'm proud of, which is some of the things that they've done with computerized, what we call computerized electronic records or continuous electronic records. The progress that they've made is fantastic. There's still a bit of a way to go on that, but it's really exciting to see where we're going to be probably towards Q3 of this year. And then finally, the big reveal will be happening around June or July. Some of the things that are most magical about your experience with ChatGPT, the interrogation of the records, narrative free text questions, and answers, and a whole range of other functionality is going to be built in and revealed to the industry. So that's super exciting. It's going to be a great 2026.
Yeah, sounds like it.
Well, thanks very much, Brendan. I really appreciate you coming on. Great to have you for the first time. And thanks to everyone for listening. Cheers.